SJC-12260, D&H Distributing Company v. Commissioner of Revenue.
Mr. Olson, good morning.
Thank you, Mr. Chief Justice, and may it please the court. My name is Philip Olson, and with me today is my partner, Jonathan Block, and we represent the appellant, D&H Distributing Company. This case involves what is referred to as the drop shipment rule, which is defined as part of the definition of retail sale in Chapter 64H, Section 1. The drop shipment rule creates a legal fiction where a wholesaler like D&H is deemed to be a retailer or a vendor, an otherwise non-taxable transaction is deemed a retail sale, and the wholesaler is held liable for the sales tax. Briefly, factually, D&H is a Pennsylvania-based wholesaler of consumer electronics and other items. It primarily sold to retailers, who in turn sold to consumers. It had a single employee living in Massachusetts, and although it was a wholesaler, it made a nominal amount of retail sales in Massachusetts. D&H registered, filed sales tax returns, and pays sales tax on that nominal amount of retail sales, which was about 1% of its total sales. Those transactions are not at issue today. What is at issue are the wholesale drop shipment transactions, which amount to about 99% of D&H's business. The basic drop shipment transaction involves two separate sales and three parties: a consumer, a retailer, and a wholesaler. First, a Massachusetts consumer purchases a product from an out-of-state retailer. It could be a small store or it could be Amazon. Usually this transaction takes place online. Next, the out-of-state retailer purchases the product from D&H. And finally, the out-of-state retailer instructs D&H to ship the product to the Massachusetts consumer from one of D&H's warehouses.
Is that why you say it's not a retail sale under 64H Section 1?
Basically, they're creating a legal fiction here. This is a three-party transaction. Normally, this would be considered a resale. The retailer buys it from the wholesaler, right, in turn resells it to the consumer.
But I'm not trying to oversimplify your argument because it's sort of complicated, but aren't you saying if you look at Section 1 that what happened here is not a retail sale?
That's correct. The retail sale takes place between the out-of-state vendor and the consumer. What the statute tries to do is substitute the wholesaler, D&H, in place of the vendor, saying for this retail sale, and in fact it is a retail sale, for this retail sale, you are now the vendor of that property.
Okay, so let's look at the practical consequences if you're right. If I go online and purchase something from, say, Costco, who I guess is a Massachusetts retailer,
right,
I pay sales tax. Sales tax is charged to me.
That's correct.
If I purchase it from some entity that does not otherwise do business in Massachusetts, and they arrange with you to deliver it to me, then if you are right, then those purchases would be free of sales tax.
That's correct.
And it would be the burden on me to pay use tax.
That's correct, Your Honor.
Would make me the only person in Massachusetts who actually pays use tax.
I think in one case it estimated less than 5%.
Okay. So the practical consequence of what you are proposing would be to give essentially a 5% cost advantage to out-of-state retailers with regard to computer sales.
Well, out-of-state retailers have that advantage now under Quill because they can safely sell into Massachusetts under Quill because they do not have a physical presence in state. So that's a problem that's been there forever.
But where they deliver it,
they do deliver it on behalf, but the solution is not to punish D&H, which is what this statute does. It says we cannot get this out-of-state retailer. Quill prevents us from doing that. And we see a problem because people do not report the use tax as they're supposed to. So our solution and our interpretation of this drop shipment rule is to put the onus on D&H to pay the tax.
What if D&H decided to take their representative in Massachusetts and move the representative to Connecticut?
The problem goes away for D&H because the only way the drop shipment applies under the commissioners and the board's theory, one of their justifications for the imposition of the rule is you have that single employee in state. That coupled with the fact that you make retail sales, a very nominal amount, but technically you make retail sales, and for those sales, you're a vendor.
Can you explain to me, I'm sorry, I didn't mean to interrupt you.
Sorry.
Why is this suddenly a problem? I mean, it sounds like this happens all the time. So what happened to get D&H into trouble with the commissioner? Was there an audit or something? How did that come about?
There was an audit, and effectively it was the luck of the draw. This drop shipment rule has been on the books since 1967, well before the internet was envisioned. And I would submit that the way it's being applied today in a situation where D&H has 20 to 30,000 out-of-state retailer customers, the rule is completely unworkable. But it's been on the books for 50 years, and there's no reported decision addressing the drop shipment rule. The commissioner cites in his brief some letter rulings discussing the application of that presumption in Section 8A, which we would submit doesn't work here. But other than that, there's been nothing to address this rule. D&H just had bad luck.
There was a California case. Where does this play out other than this Commonwealth?
My understanding is there are 4 states that have this rule. California had that Lyon decision, which is a different fact pattern, kind of more of a one-off transaction with a single out-of-state retailer. And in that case, the property here, D&H delivered it from outside the state. In that case, the property never left the state. It was always in. But as far as that's concerned, there's been a couple of cases that indirectly reference it. A New Jersey case that discussed one of our arguments that the wholesaler has no way of determining what the retail price is because it has no relationship with the consumer.
They don't care. They're willing to do it on wholesale price.
Well, they are, Your Honor.
So that's not your problem, right?
Well, that's what the board said. The board, taxpayer argued, say we have no contractual relationship with the purchaser. There is no way we can determine the retail price. And the auditor, during the audit, could not determine the retail price either.
So that's not a problem if they're willing to settle for the wholesale price. It's better than not having taxes paid at all, right?
It is, but the statute requires technically the D&H report the retail price. And if it has no way of doing it, what the auditor did basically was come to an equitable solution. I can't find out the retail prices, which the statute requires, so I'm going to use the wholesale price. But I would submit that the statute does not allow either the commissioner or the board to compromise the specific language of the statute.
But you're in the best position to know what the retail price is. You
Well-
have this complicated form that you have all of your customers fill out. Why can't you find out that way?
Well, I would disagree to a certain extent that it's a complicated form. It's a credit, by its terms, it's a credit application, and it does ask whether or not you're registered to do business in certain states, which it uses that term interchangeably with, do you do business in these states? But it qualifies both of those phrases. Do you do business in these states, in the states to which we will deliver property to you? And I don't have a complete understanding of what that's supposed to mean, but looking at the scenarios that D&H sells, if you go online and order from Best Buy, you can either have it directly delivered to, Best Buy will buy it from D&H. You can have it directly delivered to your home, or you can have it delivered to the store. And Mr. Mizell, the witness for D&H, testified, these transactions are broken down, ship to, bill to. So in one situation, the ship to address is you, and bill to is Best Buy. And in the second situation where it's delivered to the store, the ship to and the bill to are the same. They're both Best Buy. So in those situations, D&H is delivering property to Best Buy in Massachusetts, so we would need a resale certificate because they don't know if they're going to use it or resell it. But the vast majority of the other transactions, they are resales. They are sales for resale. And the drop shipment rule effectively kind of ignores that and goes to and say, we need to hold somebody liable here. We're going to hold the wholesaler liable. But technically they are, and admittedly, and the board certainly in spelling out a typical transaction, these are all sales for resale. D&H sells it to the out-of-state retailer, who in turn resells it to the consumer in Massachusetts. But that, touching upon your question, that application doesn't even begin to get into the level of detail required to determine if a company's engaged in business.
But if you had to know, you could do it, right?
Well, we'd have to do it 20 to 30 times, but engaged in business in the Commonwealth is the operative phrase here. It's the phrase the commissioner says, we can't determine this. This is an insurmountable burden for us to do it, to determine whether or not these companies are engaged in business in Massachusetts or are not engaged in business in Massachusetts. They put that responsibility on D&H, but that phrase has been in the statute since 1967, and the commissioner in 99, letter only 99-1, which is attached to his brief and referenced, 99-1 says that phrase not only means is the out-of-state retailer engaged in business, but also its agents, its affiliates, independent contractors, any entity that can help that out-of-state retailer establish and maintain a market in Massachusetts. So what the Commonwealth is asking D&H to do is not only do an examination of every single retailer that it does business with, and they do business on a rotating arrangement, so facts could change, facts could evolve, but not only do it for those 20 and 30,000 retailers, but do it, find out who their affiliates are.
Well, engaged in business in the statute would have to be limited by the United States Supreme Court case, the North Dakota case.
Correct. And
So it's not, I mean, you make it sound horrible, I'm not saying it isn't, but it's not as horrible as that, because you got a limitation from the United States Supreme Court as to what engaged in business means.
that's true, Your Honor. And the department recognized that there was a problem when Quill came out in 1992 saying you need physical presence, and if you take a look at our statute at face value, it's unconstitutional because it says exploiting the market by any means whatsoever, and that clearly would involve activity not necessarily requiring a physical presence. And it announced in Technical Information Relief 96-8 that it would only enforce that to the extent allowed under constitutional limitations. But the statute itself, it's been 25 years since Quill, the statute remains the same. So a literal reading of the statute could cause a wholesale like D&H or anyone trying to interpret it saying, well, this is what the statute says. And, and they're gonna have to investigate to what extent constitutionally does this reach?
Well, they're going to, when the Attorney General stands up, she's going to talk about Section 8A and the presumption.
Right.
So why aren't you a vendor under 8A?
Well, under 8A, we're a vendor for the 1% of the retail sales. What the commissioner and the board did using 8A is apply it preemptively. Because D&H is a vendor for that 1% amount of sales, they're using the presumption to say you're a vendor for all of your sales, even your wholesale sales. Those are retail sales now because...
I thought they were saying that you're not a vendor when the retailer doesn't do business in Massachusetts. That's what I thought they were saying.
You are a vendor when the retailer does
You are a vendor, excuse me.
But if you look at Section 1, I think the 8A doesn't apply because they're trying to apply it backwards, saying we're going to use this as part of the one test. But the language in Section 1 says if you go through the process, delivering property on behalf of an out-of-state retailer, they're deemed to be the vendor of that property, which illustrates the sales tax as a transactional tax. You look at the transactions, not necessarily the category of the person. You have to determine whether that transaction is a taxable sale. So you have to make that determination first under Section 1, because they're a wholesaler until they are deemed to be a vendor under Section 1. And I know I'm running short, but just one point, Your Honor.
So before you go, this resale certificate which you have, say for Best Buy, you have a resale certificate from Best Buy? Or from keep Best Buy out of it. You do have, for some of your customers, resale certificates, correct?
Some, correct.
And what do they say?
They're saying, they're basically confirming what the transaction is. I am buying this product from you, D&H, but I am reselling it to.
Does it identify whether they're doing business in each of the 50 states?
No. Again, that says they are doing, it asks, what states are you doing business in, and to which we will be delivering property directly to you.
So it does, the resale certificate which they give you says we are doing business in the following 30 states.
Correct. It's saying like we are doing in business in Connecticut, where you will also be delivering property to us. It doesn't ask, are you doing, it doesn't get into, it doesn't elaborate on that in the sense that if you're doing business in a state, whatever that may be interpreted, but you're not having property delivered into that state, then there's no requirement that they list that state on the application. But just one final point, Your Honor, on this.
One final point.
The traditional rule is the vendor collects the tax from the purchaser. Section 3 of 64H says vendor collects it from the purchaser. It's a debt from the purchaser to the vendor. In this situation, there's a mechanism for the vendor to be reimbursed for the tax. The application of the rule as the commissioner would have it, there is no mechanism at all for D&H to be reimbursed for the tax. They are being charged with effectively with paying the sales tax on behalf of others, because there's nothing in the statute says they have no relationship with the consumer. They cannot collect it from the consumer. They have no contractual relationship whatsoever. The out-of-state retailer is protected from quill. It has no obligation to collect sales tax from the purchaser, and it has no obligation to reimburse D&H. So D&H gets left holding the bag, and they're responsible for the sales tax out of their own pocket.
Couldn't you just refuse to do delivery directly? Couldn't you just say to your customer, who is the retailer, you deliver it?
Well, effectively, that's their business, Your Honor.
Well,
if
I
they
mean,
tell
it's
them.
if it's in a matter of who's going to have what money go where, isn't that a matter of just of dollars and cents, which way
Well, then
it's profitable for your client to operate?
then you get into kind of a constitutional point. It prevents D&H as a registered, as a mass vendor. It deters them from doing business with out-of-state retailers because there's an economic disadvantage for them dealing with an out-of-state retailer versus an in-state retailer.
So what you're saying is there is a mechanism under this use tax, albeit not widely used, and we shouldn't look to you to pay the sales tax.
Correct. That's how it's supposed to work. And to the extent the rule should apply, it's up to the commissioner to prove that this is a retail sale. And this drop shipment rule is within the definition. And the commissioner has to prove that first it qualifies as a retail sale.
Going to Justice Lang's point, more modestly, why can't you just say, listen, we're going to have to swallow the 5% tax for this transaction. We're going to charge you, as part of the wholesale price, we're going to charge you 5% more than we otherwise would because we got to swallow the tax.
Well, then you get in a business decision from the out-of-state retailer saying, well, if you're going to charge us 5% more, we'll just buy it from somebody else.
Okay, thank you.
Thank you, Your Honor.
Ms. Green, good morning.
Good morning. Thank you, Your Honors. May it please the Court, Julie Green for the Commissioner of Revenue. This case presents the question of who should bear the burden of proof in this abatement proceeding. And the answer to that question, I suggest, is that it should be on the taxpayer for essentially two reasons. First, that rule accords with the existing legal framework that first traditionally places the burden of proof on the taxpayer in an abatement proceeding. And second, Section 8 places the burden of proof on the vendor in a sales tax situation. And my second fundamental reason is that the rule makes particularly good sense in the circumstances of the drop shipment rule, and there is no reason in the drop shipment rule to depart from the longstanding rule. The rule makes good sense because first, it gives the party with the ability to gather the relevant information an incentive to do so. Essentially, it puts the factual burden on the party with better access to the facts. And second, the opposite rule, placing the burden on the commissioner, would defeat the purpose of the drop shipment rule by severely undermining the commissioner's ability to enforce the rule. As Attorney Olson alluded to, there were 20 or 30,000 retailers here, all of whom the commissioner would have to chase in order to establish their nexus to Massachusetts. Being forced to do so because D&H chose to do business with that many retailers would place such a severe burden as to render the rule largely unenforceable in this case. So I want to highlight for you 6 key facts in this case that I think illustrate why the rule that I'm advocating makes particularly good sense in the circumstances of the drop shipment rule.
In the context of this, at some point, could you address the contention that the reason that the drop shipment rule is really being enforced now is because the alternative is the use tax, which simply means that there won't be revenue coming in to the department?
Yeah, the purpose of the drop shipment rule is indeed to close a loophole in the tax rules. I want to be clear, Attorney Olson alluded to it as a legal fiction, and I do want to be clear that his challenge today, as I understand it, is not a challenge to the validity of the drop shipment rule or the legislature's ability to impose tax in these circumstances. I don't understand that to be the challenge. But the question I think you're asking is, well, is this an illegitimate purpose? And I think the answer is the opposite, that the purpose is to close a loophole that exists by virtue of the jurisdictional rules created and established by the Supreme Court. In other words, where a seller like D&H with nexus to Massachusetts delivers a product to an end consumer in Massachusetts, normally in those circumstances, the seller would be a vendor and would be required to collect sales tax. But if a seller routes the sale through an out-of-state intermediary retailer, out-of-state retailer, and then back into Massachusetts to the end consumer, that sale, absent the drop shipment rule, would be non-taxable. And the purpose of the drop shipment rule is to...
It would be taxable, but only by virtue of the use tax.
Exactly, only by virtue of the use tax, which I think we all agree has a very low enforcement rate. So rather than that, some states...
Is that your problem, not his?
The legislature has decided to enact a rule that does render certain transactions, those three-way drop shipment transactions, subject to a sales tax in order to increase enforcement and collection. And I think its power to do so is not challenged here, or the fact that it has rendered that type of transaction taxable under the sales tax rather than the use tax is not challenged. The idea of the drop shipment rule is really to pick up where the ordinary sales tax would leave off and to avoid creating an incentive for wholesalers or for sellers to create out-of-state intermediaries to route their sales through in order to avoid the operation of the sales tax. And I would refer you to the California case Lion Metal, which explains the purpose of the rule in upholding it against a challenge to its validity.
Your 6 key facts.
My 6 key facts, thank you, Your Honor. All right, first of all, there's no dispute here that D&H has nexus to Massachusetts, notwithstanding that it's located out of state. And these all involve sales of goods to Massachusetts consumers. Second, there are some 20 to 30,000 retailers involved. We've discussed that. Third, the auditor, when making a determination that the particular transactions on which tax is being assessed, when he made that determination, he wasn't simply sitting back and saying to D&H, you prove otherwise. He made the determination based on 4 items of evidence, which are quite substantial in the circumstances. Number 1, each of the retailers had an out-of-state bill-to address. Number 2, None of those retailers had registered themselves as doing business in Massachusetts in the Commissioner's database. Number 3, the auditor actually invited D&H, as part of the audit process, to submit any contrary evidence, which was in D&H's possession, to indicate that the retailer did do business in Massachusetts. Number 4, the auditor, in fact, directly went out and contacted D&H's largest out-of-state retailer, an affiliate of D&H called Data Solutions, which accounts for 33% of D&H's sales at issue here. The auditor contacted, made several efforts, and Data Solutions refused to respond. Being out of state, it's, I think, essentially beyond the Commissioner's reach. Number 4, D&H had an actual practice of asking its retailers for information about their doing business status, and in fact, collected certificates for resale, which is something that wholesalers traditionally do. It is a normal part of the sales tax framework that if you're a wholesaler, you are presumptively subject to sales tax unless you collect a resale certificate. So wholesalers routinely, as part of their business, not only in the drop shipment context, but routinely, are in the position of having to affirmatively collect information from their retailer customers. Number 5, D&H's witness at the hearing before the Appellate Tax Board unequivocally admitted that D&H's customer application would tell D&H whether the retailer does business in Massachusetts or not. If it's filled out properly, it would reveal that information. And that customer application, you can see it at Appendix 106 if you'd like to see the question asked. And number 6, at the hearing before the Appellate Tax Board, D&H did not submit any contrary evidence indicating that any of these out-of-state retailers did business in Massachusetts. It did not submit any of these customer applications that might have said, yes, we do business in Massachusetts. Instead, it relied on the argument that the burden should be on the Commissioner. So, with that, I would like to turn to the heart of my argument and the sort of essential reasons why the taxpayer should bear the burden here. The first is the traditional rule that the taxpayer bears the burden in abatement proceedings. In fact, I think as I read D&H's reply brief, it essentially agrees that this is the rule and the rule should, it's not challenging the rule. I think its position is that there's a burden that arises before that point that the Commissioner failed to satisfy.
Let's step back to, let's assume you prevail. What does a business like D&H do to protect itself under these circumstances? What is sufficient? You're not really asking them to do a comprehensive analysis of each customer to determine, regardless of whether they register to do business, whether they are in fact doing business. What are they supposed to do?
In my view, it would be as simple as asking the out-of-state retailer. I think, this would be, I think, ultimately a factual question for the Appellate Tax Board. But I think if D&H had simply taken its customer applications, in which it does ask the retailer, where do you do business? And the taxpayer, the out-of-state retailer had written either, yes, we do business in Massachusetts, or no, we don't do business in Massachusetts, and taken that information, any answer that said, yes, we do business in Massachusetts would be sufficient to avoid liability for sales tax for D&H.
So they could rely upon that even if it were to turn out, based on further analysis, that perhaps that's not accurate.
In my view, that probably would be sufficient. I think that the Appellate Tax Board would probably find that information to be sufficient. Obviously, looking at the form in light of the attendant circumstances, it would be a factual finding. But in my view, it probably would be sufficient, and I would particularly point you to Section 8 of Chapter 64H, in which there's an analogous process by which wholesalers always have to ask retailers for resale certificates. And the statute provides clearly that a resale certificate taken in good faith, the wholesaler is entitled to rely on it and isn't required to vouch for its accuracy. And I think that similar good faith requirement would apply by analogy here, and I think that's what the Appellate Tax Board would do.
As far as the taxpayer having the burden, I think that's where you were. I think that D&H's position is that the taxpayer does have the burden, but but somehow it has to be a retail sale first, a sort of a burden of production that comes first before the taxpayer has the burden.
So I wouldn't disagree that the commissioner does have an obligation in the first instance. The commissioner certainly has a burden to assess the tax in a manner that's not arbitrary and capricious, that's not lacking in foundation. If the commissioner does that, the taxpayer has an opportunity to challenge the assessment at that stage on those grounds. Now, this taxpayer did not challenge this assessment as being lacking in foundation. I'd argue then that type of challenge has been waived. At that point, the assessment is entitled to a presumption of correctness. And there is, I'm not sure that this court has spoken directly to that, but certainly the United States Supreme Court and very recently the First Circuit has spoken to that point, the presumption of correctness. That is, I'd say it derives from the entire scheme of administrative law that begins from the premise that agency action is presumptively correct until the challenger shows that it is erroneous. So we begin from a presumption that the assessment was correct. And I would stress again here that this is not a case where the auditor simply came in and said, you know, you taxpayer, I'm going to assess you sales tax on your yacht. And the taxpayer said, but I don't own a yacht. And the commissioner says, well, you proved that you don't own a yacht. That wasn't the case here. The auditor, in fact, went to great lengths, going so far as to attempt to contact Data Solutions for information about Nexus and obtained all of the information available, all of which pointed unequivocally to the non-nexus of the out-of-state retailers. Let me talk about better access to the facts, because I think that's, again, another traditional rule that applies well outside the tax context that traditionally points to placing the burden of proof on the party that has the better access to the facts. I want to particularly bring to your attention the Rodman case, which involved a cigarette excise tax on a cigarette seller. And there, this court said very clearly, it faced a situation where there were certain cigarettes that had simply gone missing without explanation. And the question was, had the cigarettes been sold such that they were subject to tax, or had something else happened to them, non-sale, that would have rendered them not subject to tax? And the court concluded that the cigarette seller should bear the burden of showing the non-sale in that situation, because the cigarette seller is the one with the best access to information about the circumstances of the cigarettes and what had happened to them. And that same principle, I think, also animates Section 8, the burden of proof statute. So the sales tax laws have a somewhat unique statute, Section 8, that specifically establishes a burden of proof and places it on the seller in a sales tax situation, on the vendor, technically.
That's a presumption.
It's a presumption, and it can be overcome with evidence such as a resale certificate, but it places the burden of proof squarely on the vendor. And I'd submit that the principles that animate the Rodman case are the same that animate Section 8, and the same that I think militate in favor of placing the burden of proof on the taxpayer in this case.
Is the key to understanding this who has the burden of determining whether the retailer does or doesn't engage in business in Massachusetts?
I'm not sure I'm understanding your question, but my answer is that it's a burden of producing evidence that the retailer does do business in Massachusetts. I'm asking the taxpayer to provide evidence to show that the retailers do business in Massachusetts.
And who has the burden of showing that?
So the question presented by D&H is who should have that burden?
Right.
My answer to that question is that it should be the taxpayer for the reasons that I've outlined, and that Section 8 requires it by its plain language. And even if it doesn't, that the same principles would mandate that result as a matter of common law.
Okay, thank you.
Thank you very much.
And we'll take our morning break.